That's how really I think we got to this point in our country where we are starting to worry about what is it that people can tell about us from what we're wearing, how we walk, our fingerprints, and so on and so forth. So that's kind of the real world perspective of it. To take it back a little bit historically, because that's kind of where we are now, and to root it in the privacy debate. Now, India has had a privacy debate since we were formed, actually. There are many important constitutional cases that go back to the 50s relating to police detention, relating to Menaka Gandhi's passport being kept aside and not letting her travel. So many of you who have lived through many of these stories will remember PUCL, of course, has had many cases about privacy. Mr. X versus Hospital Y was about a person who had AIDS and whether the doctor should tell their spouse that they do have it or their spouse to be. So these are all questions of privacy. But the most recent story and iteration of this larger story of privacy really begins in about 2010, 2009, when the government sets up the Aadhaar project. And with that, they also realized the DOPT, which is the Department of Personnel and Training, also create this approach paper on privacy. Because, we are actually quite a smart country. We have some very intelligent bureaucrats and other kind of people in the process. And they have this approach paper which says, we are going to digitize. Everything is going to go through these large databases. That's going to open up people to the risk that they are going to be watched, whether or not they are under suspicion for a crime, right? We're going to have to access, you're all going to have to be data points, but how do we keep this trust in this digitizing society? Now, in 2012, that's a few years later, there's actually a committee set up by Justice A.P. Shah of Supreme Court, and they say we're going to actually have a consultative process, come out with a report with 9 privacy principles. And these 9 privacy principles should become a law. And actually in 2014, we came this close to actually passing a privacy law, and that was leaked to the press and so on. But of course, there was an election around the corner, and that kind of took a backseat. And of course, a lot of what we're kind of dealing with are the consequences of that election as well. But what then happened is also at the same time, there was a case filed, and this is all happening privacy as Aadhaar is also unrolling, right? To take it back to the kind of court system meanwhile, in 2012, so there is a commission looking at privacy and so on. There is still no law per se. We are collecting the entire country's biometric and other information, and other systems are quickly getting digitized. There was an old judge of a retired Karnataka High Court judge who filed a case called the Puttaswamy case. His name is Puttaswamy. I recommend you go to YouTube and check out his videos. He's incredibly endearing as well. And he essentially looked at what was going on and he said, this doesn't sound right, doesn't pass the constitutional spell test. I'm going to file a petition. And all of this really took about 6 years while Aadhaar was unrolling, and this case and several other petitions were going through the court system until in 2017, they all were put up to the Supreme Court. In the course of that, the Supreme Court said the constitutional question of whether we have a right to privacy hasn't really been, kind of determined clearly and without doubt. And that's how we came up with this case. And why this case is important is because it said for the first time that it's not just Indians who need privacy, it's our informational privacy is a part of privacy. So to tie it back to what I was talking about, the information society, we're all we have to deal with information systems, right? I mean, unfortunately or fortunately, we cannot go back to paper because unfortunately or fortunately, that's where we are. They're saying in this information society, this citizen also has informational privacy. So privacy is an extension of who you are. It is yourself. It is not your property. It is not your land. It is an extension of yourself, your life, your right to live, right? And they root it in Article 21. They say it's a natural right. So actually it exists even before the Constitution. They root it in Article 19, which many of you will know about speech. They root it in equality. And they essentially say to live in a communitarian society like India, we need privacy. Because we choose what we want to tell our spouse, our family members, our neighborhood Khat Panchayat. We need a level of privacy to ensure that we are able to have social relations. And what then happens is government, now it's very interesting, the reason I wanted to give you this background, and I'm going to quickly use about 5 minutes if I have the time, I think I do, yeah, to kind of take you through this bill, right? Because it's at this point that government becomes very serious again about having a bill or an act to cover your privacy rights. And it's very much linked to Aadhaar, I think, because this privacy question was so central to Aadhaar that, and the law of the land is that if there is no existing legal act which covers your rights, the Supreme Court can make law. And that's law until government passes the legislation. So the government was actually concerned that the Supreme Court is going to come in here and give us a law of privacy. So this is the background in which the process we've all been involved with for the last 3 years unfolded. In 2017, a committee was set up to consider the data protection framework for India. Just after the judgment, actually, the right to privacy judgment, the white paper of that committee was released, and the court actually said this committee is now in place, so we will not set out a law of privacy, we'll just say that it exists. And then that committee had a final report which was released in 2018, the same year that the final Aadhaar judgment also came out, and it had to be restrained by this Supreme Court judgment. And it had to agree that in some sense we do have a right to privacy, and therefore any infringements of your privacy, that is a feeling, any access to your information, needs to be necessary, and it needs to be proportionate to the aim achieved. So that means, like, if I need to access, I'm your doctor, I need your medical records, it's fine for me. That's proportionate to the service. I am Uber and I actually just want your blood group because why not? That's not proportionate. So it's a pretty simple and clear test. Interpretation is not, that they have put out in this judgment. And that's kind of what this bill was really supposed to bring and flesh out. Now, what does it do? I'm just going to call out 4 or 5 things, happy to discuss further. What it does for the first time is that it sets out grounds for access to your information. So right now, anybody can use your personal data. They have to have reasonable security practices and procedures under a very old law called the Information Technology Act of 2000. But it's pretty worthless for reasons we will not get into at this point of time. So what they say is that you need to select why you are accessing your data. So that's what a company or the state has to do before it accesses the data. It needs to be through consent. They have to ask you for consent, or they have to use it for a reasonable purpose, and several other grounds, or for national security. What it then does is it gives each of us certain rights, 4 rights, which again, happy to cover in comments. It puts certain obligations on entities that are processing your data to not abuse the information. They have to have it securely. They need to not collect unnecessary data. They need to retain it with safe security. They need to tell you if your data has been breached. And then finally, it set out certain exemptions. And it sets up a new data protection authority. And really, if I had to kind of pick one of the many things to call out from this bill, because it's a vast bill and we've all still been reading it after 3 years, is that this data protection authority could really be the litmus test of whether we have a good or a bad law. Because this data protection authority will enforce infringements of this law. And unfortunately, there are several changes in the most recent draft of the bill that has been introduced in Parliament, which severely weaken the data protection authority's independence from government, and also severely restrain any discretion it removes any fetters on discretion. So you have a very not such an independent data protection authority, which can actually act arbitrarily. So it could use its powers, which include the ability to put people in jail, fine you, sanction you, fairly arbitrarily when it wants to. So this is a concern. Also, and this is the last thing I wanted to call out, it gives immense powers to the state. So there's a section 35 that if there's one number you remember from this conversation, it's section 35 of the bill. Essentially, it allows central government to, by order, vacate data protection rights and privacy rights for anybody, for any other government agency. So the ministry can essentially say, privacy rights do not apply when X government authority needs your data. So it can say, if the PDS system needs your data, your privacy doesn't apply. If, for instance, your National Highways Authority needs your data, privacy doesn't apply. So just by an executive order, vacate your privacy rights. I do not know if this will pass constitutional challenge, but it's in the bill. And that's, I think, the biggest concern. And so to be honest, just a practical point, whoever can, please do write into the Joint Parliamentary Committee. It's still open. Unfortunately or fortunately, we have the political system we do. The fact that we use even the few opportunities we have so less is a tragedy. We are in a state where 110 bills are being passed in one session of Parliament. So part of it is that is problematic, and you need to be a bit more thoughtful in your public discourse. But if Parliament is being so quick in considering this, we also need to respond. So there's a 3-week window right now. I think until the 25th of this month, there's a joint parliamentary committee. Meenakshi Lekhi is the chair. You can write directly to them with concerns, maybe organize as PUCL, put in as many, publicize your responses, talk to people about what can change, because it's really the last window.